So in the studios today, we have Melissa D'Ellena with D'Ellena Law, and we have TJ Ciolfi with the DiSpirito Team, who is our estate specialist on the team. What can you tell our listeners about estate sales?
So as it pertains to an estate sale, if you are purchasing a property as a prospective buyer and you identify that the property is subject to an estate or somebody has recently passed away, that should be a red flag for you that there may be some potential delays, and there's definitely a court procedure that may be required for moving forward with the conveyance. Probate, definitely will be something to consider, especially if the property was owned just by one individual who is recently deceased. The other option that we see sometimes, and we talk about this a lot with our prospective buyers, is joint tenancy. So if you have two or more people who own the property together and there's a survivorship, there may not actually be a need for probate. So just because you've heard that somebody has recently passed and that's what's precipitating the sale, that may not mean that there will be a probate, but that would be the red flag to you and your agent to be asking some follow-up questions as to, is there a need for probate? Who's the probate attorney? What has been done relative to the probate process thus far, so that you can better assess the timeline.
Yeah, and this area is even a gray area for most realtors. So, a lot of real estate agents think that these are questions on the real estate exam that they'll never have to look at again. Probably not the person you want to hire to take care of your estate.
Absolutely. Having somebody who is well vetted in the background of handling estates, have done listings for estates in the past, those agents are going to have a really firm understanding of the court process and be able to give you a better procedural understanding. And if you've already got an agent and somebody dies during the transaction, which is quite unfortunate but does happen, at that point you're not going to fire your agent and get a new one. So you better hope that you've got a good lawyer and that you certainly can get them on the horn to ask these questions, because at that point it really becomes, attorney consultation with the client as to what's going on and what the timeline expectations are.
A lot of times, too, when somebody passes away, it's a very sour subject. It's a very sad, sad time for families, and they don't really want to be thinking about all of the implications that can come from this.
It's true, and a lot of times there's more than one decision maker. And someone may be appointed the executor or the administrator of the estate, but they still have to get on the same page with a whole team of people that maybe have a different agenda. So you may have one person who wants to sell the property immediately and cash out, close the books on the entire estate. And then you might have someone else that wants to make upgrades to the property to try and get top dollar. So one of the challenges that I have when I'm dealing with probate estates and these things is getting everybody on the same page so that we all understand there's a timeline that's a lot different than a regular transaction. There's a lot more time spent talking to attorneys, definitely, and that's a real key, going in.
Some good points. Melissa, what kind of legal snags have you seen, as far as the states with that many people involved?
Right. Well, one of the, first things that you pointed out, TJ, is an executor versus an administrator. If the person who's owned the property and passed away had a will, generally speaking, in that will, it would designate a person that they appointed to handle their affairs in their absence, and that is the designated executor. That person usually in the will have the discretion to sell the real estate. It's called a power of sale. And that power of sale gives that one person the authority. Now, they might still be talking to their family members or their other loved ones as to what should they do and from a timing perspective, but at least you have one decision maker appointed, or two decision makers if there's co-executors, as it were. The other alternative is in the event that the person passed away without a will. In that case, the property has to be open for probate, then an administrator is appointed by the court, and at that point, everything has to pass through the court. So there is no power of sale. The court has to sign off on the sale. The court needs to see contracts, valuations, appraisals to determine, is this a good sale? Is it in the best interest of the estate? And then the court says, okay, now you can sell consistent with this contract. There's also a 20-day appeal period from that court order. So at that point, the buyer is just sidelined waiting to make sure there are no heirs who would potentially appeal that order.
Now, is there anything our listeners should know on how to prepare an estate?
Relative to proactive, you mean?
Yes, to be proactive.
We get this a lot, especially because I deal with a fair number of first-time home buyers. So then they say, well, now I own a home. Shouldn't I have a will? And the answer is yes, absolutely. You have assets. You have probably children that is one of the main reasons that we talk about creating an estate plan, is to identify a potential guardianship to rear your children in the event that you're no longer able to do so, and to identify who you want to administer your assets. Again, these are all statutory authorities that the fiduciary, executor, or administrator has. So you're certainly going to streamline the process and make it easier to the extent that you have somebody designated and you have a written will in place. And it really minimizes, well, I can't say minimizes. It simplifies the process so that the costs are less. Probate is an expensive undertaking. It can be anywhere from $2,500 and upwards, depending on the size of the estate, the number of assets that are held. But having the writing, which is a will, is certainly going to make for an easier process. So to the extent that there's not a will, the laws of intestacy in each jurisdiction will identify what happens to your assets. Generally speaking, if you pass away, all of your money will pass to your heirs. That's a bloodline. So that does not include a spouse, which is usually quite surprising. So it will pass down to your children. If there are no children, then it goes up to your parents. If your parents have predeceased, it goes out to your siblings. Now, there are what's known as life estate valuations for the spouse. It's a spousal right. So there may be some authority and some interest that the spouse can claim. But if you don't have a will that has designated all of your assets go directly to your spouse, then it really is going to pass through your bloodline. So certainly illegitimate children, or any children for that matter, would be the first in line. So it's really surprising to hear of people with that kind of means not having estate plans in place. It is important. And, a lot of my clients actually go so far as to put trust agreements in place.
Yeah.
So when you have assets and your net wealth is in excess of $1 million, we would normally recommend talking to an estate planning attorney who specializes in trust, because at that point you can really start to get into some tax avoidance on the estate side. And in that case, you have to retitle all of your assets. The real estate could be held in trust, and then you have a trustee's deed. You have a trustee's sale. There's no courts involved, but there's no probate either. So it makes, again, for the process to go a lot quicker.